Hello, everyone. Welcome to the third and final session of today in what is the third day of the ICC UK Annual Conference. I'm Ian Quirk. I am one of the deputy chairs of the ICC UK Arbitration Committee. And I'm delighted to introduce this session. Before I do, can I just say that there is a Q&A button at the bottom of your screen. Please use that Q&A, not the chat, but the Q&A, to ask any questions which will then be fielded. And so can I then introduce to you your moderator for this session, which is Matthew Saunders, who is the Global Head of International Arbitration at Ashurst. Over to you, Matthew.
Thanks very much, Ian. So good afternoon, everybody. Thanks for giving giving us your time on a Friday afternoon. It's greatly appreciated. What I'd like to do first is ask our panel members, Wendy, Vivek and Suba, if they could put their cameras on. We got Vivek and Suba, are you there? Okay. Would you like to introduce yourselves, please, starting with Wendy?
Good afternoon, everybody. Nice to see you all here on a Friday afternoon. Wendy Miles. I'm a barrister at 20 Essex and Counsel in International Arbitration and Arbitrator.
Vivek, are you there?
Hi, I'm Vivek Kapoor. I'm a barrister and arbitrator at 39 Essex Chambers, and I'm delighted to be here. Thank you.
And Suba.
Hello, my name's Suba Akhter. I'm a very recently called barrister. I thought I have to become a barrister if I get on this panel. Otherwise, I'd feel the odd one out. And also to stop my in-laws asking when I'll become a barrister. My other role is I'm head of litigation for Siemens Energy in the UK, who I've been with now for 18 years.
Thanks, everybody. Okay, so what we're going to do this afternoon is we're going to look at an area of international arbitration, an area of disputes against a backdrop where it's, I think, probably hard to find a set of greater imperatives, because the backdrop that we're talking about is a climate emergency. It's the move to net zero and the transition away from high carbon. So that's the context in which we're looking at this. In order to frame the discussion, what I propose we do is fairly quickly go through 4 slides to set out a bit of a roadmap as to where we're going to go. Then we'll go back and we'll look at the issues in greater detail. So please pose any questions that you'd like us to address as we go, and we'll pick them up. So the first area to look at is, what is the landscape for disputes in the renewable sector? So we've set it out here. It's our transition to net zero. It's the phasing down and out of high carbon systems. So it's promoting one area and downplaying another. Scaling up renewables. A characteristic of this area is the use of new technology, but also the integration of that technology with older technologies and control systems. And all of this taking place against a set of certainly political and legislative imperatives. And anybody looking at the UK political scene at the moment will see that that's playing out absolutely real time as to what kind of policy initiatives we might see coming through in the context of an election likely next year. So next we have the causes of renewable disputes. And here we've taken some results from a Queen Mary survey, but we'll come on and see how close a relationship that bears with our experiences of where disputes actually arise. Then third, we'll go and have a look in the law library. What substantive areas of law are emerging? What is new? What is old? Where's the combination? Is the investment protection side as significant as many lawyers consider it? Is that the view from private practice? So we'll look at that. And then last of all, we'll touch on some of the evidential and the procedural issues that come up in the renewable sector. And maybe it's here where some of the real challenges sit. And we'll look at the perspective that arbitrators have, the perspective that in-house lawyers have, and see what learning points might come from that. So if we go back to the first, I think, substantive area, which is the landscape of renewables. If I start with a question, I think, for Wendy, which is, how far do you see particular tensions between the need that investors have for stability in this area and the need for governments to exercise a legitimate right to regulate? How far does that tension, from your perspective, give rise to disputes? I think I'm muted, Wendy.
Thanks, Matthew. The tension possibly gives rise to more disputes in the minds of lawyers than actual disputes on the ground. I think that the direction of travel is clear. We are in uncharted territory. We've never had a transition like this in our global energy systems before. We have had other energy system transitions, but never before on an imperative through an international convention signed by almost 200 member states, which involve a bottom-up approach by each one of those states into the strategy and the planning and the implementation of the global objective to reach net zero greenhouse gas emissions by 2050 and 45% by 2035, which is terrifyingly close. In terms of the tensions leading to disputes, the transition is really the main element, I think, that's going to lead to disputes. In terms of a transition is by definition a movement from A to B, a movement from status quo to something different. And the scale of the transition, the pace of the transition, the cost of the transition, and the technical uncertainty of the transition will all generate disputes. Now, in terms of the question you ask me, what is the trigger or what is the effect of government policy? We can't assume or let ourselves believe or try to make a truth that governments have an obligation either under national law, constitutional law, or international law to preserve an entirely stable, guaranteed, never going to change investment environment for investors. And in the course of a transition, governments need to be able to be fairly flexible, fairly nimble in terms of learning from technological advances, learning from financial models that work and don't work, learn from pricing mechanisms that work and don't work. So our governments need to be able to be nimble to implement transition. We don't actually know how this is going to play out. So it's a case of balancing the general framework messaging, which is set at the Paris Agreement level pretty clearly and set in the nationally determined contributions by the member states pretty clearly, and following that path in a manner that doesn't go backwards and that continues to ratchet up. It seems to me pretty simple, but perhaps some of the headlines in the UK last week would suggest that it's not as universally simple as as one might expect. But when we talk about a stable framework, I think the movement towards electrification away from high carbon emitting systems, that direction of travel is what ought to be stabilized and what investors ought to be able to rely upon. The details, the specifics, a particular feed-in tariff, a particular contract for difference, a particular drafting of a tool or a mechanism within that framework. I think we need to accept that governments also need to be nimble so long as they preserve the direction of travel.
And Wendy, I mean, do you see the kind of tension between, the investors' need for stabilization and the state's desire to regulate, and perhaps uncertainty sometimes on the state's part as to the path it should follow for regulation? You can see that in the UK now, I think, in terms of what a manifesto is going to say in 4 or 5 months' time. Do you see that as already giving rise to disputes, or is it something that's over the horizon?
Governments have to be able to shape their policy, and if the government makes a policy that says this is the way it's going to be for the next 20 years, and I'm not going to change it, then investors are in a different position in terms of relying on that. But knowing that the legal framework that's going to govern energy transition is going to look a little bit different in every single one of those 197 Paris Agreement countries. And it's going to change and evolve as we move through time. We don't know what green hydrogen, for example, is going to look like. We're struggling enough with offshore wind compared to onshore wind, for example. The economic equilibrium of solar investment is entirely different to very large technical infrastructure of offshore wind. So the government has to be able to move in the direction of technological advance and different economic movement as we transition more of an energy system towards renewables. The economics will change in that, and I think the government has to be able to respond to that. And so it's in a way, it's what expectations do you set down for investors? It's in a form, it's disclosure in many ways. What are you telling investors that the situation is going to be? What are you putting into your investment agreements, into your contracts in terms of the terms of those contracts, but any stabilization within those agreements? And then what room are you leaving yourself to move? And naturally, the more flimsy your policies and framework and incentives for transition, the less a state is committed to transition in its policies and in the mechanisms it adopts, the less likely investors will invest the majority of their money in that state. And we've seen huge shift in investment to the US when the Inflation Reduction Act was put into force. So does a dispute arise from the government changing its policy? Well, only if the government makes representations that it's never going to change its policy. And there are situations of that, but the stronger and clearer the government is about that direction of travel and ratcheting up ambition, the more it will mobilize capital into that transition, into that country.
Yeah. And Suba, from the real world, the in-house world, the world of Siemens in this case, I mean, we had identified from the law firm perspective, if you like, we'd identified specific challenges around new technology.
Yeah.
And the kind of notion that something that is cutting edge, that must be something that gives rise to problems and gives rise to disputes. Is that actually Siemens' experience?
The answer might actually surprise you and others on the call, Matthew. Just as an aside, an email came up reminding everyone about this dispute and this session, and it was renewable disputes, as if you are renewing the same disputes over and over again. And to be honest,
some are actually, but...
and the serious point is that title might not have been incorrect. And what I mean by that is, whether it is new cutting-edge technologies such as offshore wind farms, I mean, some of these things are mind-bogglingly complex, what the entire industry does, including Siemens. They are quite awe-inspiring. But the disputes are no different from our other energy businesses like oil and gas, traditional businesses that we had. The new technology and technological challenges are more an issue of logistics than anything else. And it is the technocrats and the commercial colleagues who actually can find solutions to those things. Just as an example, when I used to do rail disputes, we would have, thinking ahead, we can build all these huge trains, but the problem you've got is your Victorian era platforms are too small for them. Fast forward to now offshore wind farms, you have these blades which are huge. And the challenge is, right, find a barge that can take it, then find a port that can take it. So those things rarely result in legal challenges, and therefore are rarely causes for disputes. We'll come on to later what the causes for disputes, etc. are. But those, as I say, are more an issue of integration and logistics than legal issues, because those things are ironed out beforehand.
And Vivek, does that chime with your experience on the more kind of construction side of the bar?
Yes and no. I think a very interesting aspect of the regulation and the regulatory landscape that in my experience plays out is increasingly, I have a practice that sits between commercial and construction, and I've seen this happen, in Africa, in developing markets of Asia. The environment or the government policy is broadly favorable. So you have a favorable regulatory framework, but where the uncertainty lies is in the implementation. Because in the implementation, you get to a stage where you have domestic actors. Politics becomes a very live issue. Domestic politics as sometimes as an investor, as sometimes a global player like Siemens probably doesn't appreciate, but becomes a very live issue, and that sometimes translates into disputes. So as we discuss later, the labels sometimes are the same, but the mechanics of that dispute are very different.
Okay, so Suba, you touched on the question as to where our disputes actually do come from. Now here we've got the Queen Mary University survey results that I think were published in January this year. I must say, from a personal perspective, I always apply a great deal of skepticism around surveys. And from the law firm perspective, when you know how they're used as a form of promotion, then there's perhaps especially skepticism warranted. But when I saw these, instinctively, they seemed about right. However, you're the person, I think, with the broadest perspective here in terms of where disputes arise that perhaps external law firms and counsel might never see, because they are settled. But where do you see disputes in the renewable sector arising from?
Of course, thank you. I've got no reason to doubt the figures that are given there. The only caveat I'd give is on bullet point 2, the regulation-based disputes, subsidies and power pricing, etc., isn't something that is particularly relevant to where we sit in the chain and all the myriad of parties applying. So if you'll forgive me, if I almost ignore that bit, then the other bits are correct. So the way we look at it, and our experience is, you look at the lifetime of a renewable project, and you will typically have 4 phases. The first one is the feasibility stage, and you rarely get disputes there. You may have a dispute based on options that are put there, whether it should go ahead, notice to proceed, that kind of thing. And then you have the implementation and construction phase, and the vast majority of disputes are at that stage, and they will often be construction related, so typically about how long a project should take and how much it should cost. The run-of-the-mill construction type disputes, you will get some things to do with design and some with defects, but those disputes are all, remember, we sit in a chain. So claims can be up the chain to our customers, it can be down the chain to our very major subcontractors. But a lot of the disputes are during the implementation and construction phase. And one caveat I've just given, maybe it's something we'll pick up later, is every project, everything is a claim. Every application for payment is effectively a claim, but they don't become disputes. It's which ones then have legs and becomes disputes. There are difficult to identify at the same stage. You can have peripheral disputes like consortium partner disputes or your JV partner disputes. And again, those often are on the back of what your customer is claiming from you or you're claiming from your customer. And then you end up in a spat with your a JV or consortium partners. And the supply chain risk, it is one of the key risks, and the appetites have changed. So the causes of disputes over the last few years, we first had the pandemic, and that resulted in quite a few major disputes. For example, whether the lockdown and the social distancing, etc., were force majeure, were not force majeure, whether they entitle you to additional money or not, etc., etc. And then obviously we've now had the Ukraine war on the back of that, which has caused all kinds of models and assumptions to go out the window. So the appetite now for parties to take risks without price escalation clauses, without expanding their force majeure clauses, etc., is less from contractors. But we still have the legacy of contracts that you've entered into, and you're thinking, oh my God, we end up subcontractors are doing likewise. We priced for this, and the landscape have changed. How can we deal with that situation? So all of those fall into the middle category, as I say, the construction and implementation phase. And then you've got the next stage, which is the maintenance and servicing during the lifetime. That disputes there are rare, but they do occur. It may not perform as it should. Servicing costs might be more than you anticipated, etc. And the final phase is the decommissioning or repowering, which are even rarer still. So as I say, the causes of renewable disputes are not that different from other infrastructure project related disputes. The fact that they are renewables has an angle, but they don't ignore all of the other things that have been happening all the while. And the way to look at it is, at what stages are the highest risks of you entering into disputes? And as I said, it's really the stage 2, possibly a little bit on stage 3.
You touched on supply chain. I wonder, Vivek, from your perspective, do you see an upsurge in FM disputes, perhaps as a function of Ukraine, Russia, or before that as a function of COVID? Is that something you've witnessed, particularly in the renewable sector?
It is something that I've definitely witnessed. But the other very interesting aspect which I witnessed is all these disputes tend to settle. I've never seen them go to trial. Now, that might be a complaint from someone who just, gets involved and then it just fizzles away and your diary becomes vacant. But essentially, what I've noticed with especially with the COVID and then the Ukraine war, the related FM disputes, is commercial parties understand there is a problem and want to be sensible and commercial about it. And one of the things that happens, especially in the renewables, but in the broader energy sector as well, is the actors are the same. So, you will end up working with the same commercial parties, be it upstream and downstream, as Zubair mentioned. And you understand that they have those problems. They are real problems, and it's just not a sort of a flimsy, frivolous issue that's been raised. And I think parties and boards have been keen to look at the long-term relationship and try and take a sensible view rather than, get all locked and loaded and, go to arbitration. So notices have been issued and, dispute commenced to sort of focus everyone's mind, but invariably they're settled. I don't know what Suba thinks about that, but...
Yeah, we can come in later, but I agree with the point you've made, Vivek, is absolutely correct, which is there are limited number of players, certainly at different levels. You know, we have to deal with the same customers again and again, and equally the customers have to deal with their major contractors, whether it's us or Vestas or whoever, and there are limits to what can be tolerated by either side, even with the commercial levers that apply for repeat businesses. You know, some of these projects have to stand and fall on their own numbers.
Wendy, just picking up on the second item here, which is regulation-based disputes. I mean, something that I've had, you know, recently experience of is advising and then instituting an ECT claim against a European state that has used a long-established process for deciding on permitting. In this case, it was a financial affordability test for an oil and gas company. And the Green Party Minister of Energy refused the production permit, and that may yet give rise to a treaty claim. Are you seeing regulation as a territory already giving rise to a greater interest in treaty claims and a corresponding interest on the part of investors in positioning themselves so they get treaty coverage? Is that something that you witness?
I mean, there is an increase in treaty claims around transition, yes. I think the awards are perhaps more interesting than the claims, as with all of ISDS. I'll answer that. Can I just take a step back on this slide against the broader spectrum, away from the EPC contractor in the transition and the introduction of renewables in an energy transition? And the EPC contractor and the EPC contract sort of sits in the center. But before you get there, you need to raise finance. A lot of the finance in energy transition is being raised with the assistance of sovereign money, sovereign funds, development funds, the Green Climate Fund and the different development banks sort of using innovative financial instruments, green bonds, blue bonds, to try to raise money to go into funding the energy transition. So there's finance disputes that we are likely to see more of. Green Climate Fund uses ICC and or PCA in all of its agreements. And then when you come past financing to structuring, how a lot of the joint venture companies or the operating company, the local operating company, is structured, the shareholder structuring, if it's private equity structuring, how the LPs, GPs, but the different target companies are structured and managed. And then when you move into the actual infrastructure project, it might not go straight into traditional owner, main con, subcons model. Often there's a project development model that comes first. So a project developer will come in and work up the project and then sell it on to an owner who will then enter into the contract with the EPC contractor. So every single step along this continuum is already giving rise to disputes. And then as Vivek said, you move into O&M and decommissioning. But before you get there, in the EPC supply chain, we haven't even touched upon the critical minerals and metals that are the raw materials that go into that supply chain. So photovoltaic panels, turbines, all of these things require an enormous amount of critical minerals and metals, as do things like electric car transition and the infrastructure to support that. So all of these things are giving rise to disputes. And I think the overlay across that entire continuum chronology of investment in renewables and renewable energy systems is overlaid by every single stakeholder in that continuum now having to manage its carbon. So reduce its own, whether it's a state stakeholder or whether it's a corporate party, it now has its own obligations to report on, monitor, and reduce its own carbon, sometimes through buying offsets, which can then give rise to verified carbon credit disputes. And all of that is also overlaid by the regulatory environment. So energy electrification is a heavily regulated industry in every state I've worked with. And because it's heavily regulated all the way along from the environment, from the structuring, do you have to have a local operating company? How are you allowed to structure through your debt, your taxation planning, through holdcos, offshore, through to the actual place of the infrastructure development. So the environmental planning, the permitting, the local communities, the constitutional rights of those local communities, affected populations, ownership of the land, management of those resources, and then the construction itself and the financial model that I was trying to talk about at the start, the economic drivers that you need to bring that investment into the country in the first place may have been a bit of a hand on the weight of the scales with feed-in tariffs or free tariffs, with a fixed period on those, or other sorts of subsidies or tax benefits, and all of that, again, heavily regulated, and then the operation and maintenance and the decommissioning and the cost of decommissioning. So if it doesn't take much of a modification in that overlying regulatory environment to send a bit of a tailspin into any bilateral or multi-party relationship along that spectrum under the contracts. So just under the contracts, or under the constitutional or sort of regulatory regime disputes relating, judicial review relating disputes at a domestic level. So before you even get to investment treaties, right, you've got so many layers of potential disputes in a transition. Proportionately, the investor state claims under treaty, including the Energy Charter Treaty, are tiny compared to the contractual and judicial review regulatory type planning disputes that come up along the way. So we mustn't let the tail wag the dog. But yes, they are there, and yes, I think there is always gamification where if you can insulate or securitize an investment by having this treaty that will give you exponentially increased financial return for an investment, will people try that? Yes.
And do you see the put it diplomatically, the less than rosy picture for the future of the Energy Charter Treaty in particular? Do you see that leading to perhaps a greater focus on contractual approaches to ensuring stability rather than relying on international law?
I mean, yeah, well, yes, but also constitutional as well. I think there's some interesting, if there's a regulatory act that so fundamentally undoes the economics, you buy a farm and next minute the HS2 is put through the back of your farm. There are mechanisms available in most national laws to get compensation for that. Now, you might not feel it fully compensates you, but certainly looking at those operating environments and expecting those to adequately to cover at least your investment. And look, Matthew, would a contract, could a contractual protection give some of the protection that we've seen under some of the more profitable investor state claims? I'm not sure, but I
think we might come on to that.
They're a rare beast, I think. Energy Charter Treaty, it's going through its process where it is you know, it's in a process of phasing out. I think it's unfortunate because it's the only energy transition treaty we have. And if it were operated as an energy transition treaty mindfully for this energy transition, it could be an enormous facilitator, accelerator of transition.
Yeah. So I want to pick up on our next topic, which Vivek, I wanted to ask you, from your perspective, what areas of the law library, what areas of substantive law do you see coming up in renewables disputes, and is it any different? Are we fooling ourselves? Is the black letter law involved in any way different in the renewables sector from other areas of construction, or just other areas of arbitration? How different is it?
I think in terms of the basic law, the answer is probably no. But I think there is a very interesting aspect to the application. Now, picking up, I was going to sort of start with construction, then go to commercial, and then invest state. But I'll pick up on Wendy's comments, which are very interesting. I have seen a slight change, and she's absolutely right about the constitutional aspect, where in contracts I've started seeing stabilization clauses, which will make reference, though not very well, to international law concept, fair and equitable treatment. Make references to protections which are very broad under a constitution, which might not sit very well or are not very well defined. But what I think they've contracts still stay clear of is the sort of international law manner of calculation of damages, which is where I think investors again look back to VITs and investors say. But keeping that aside for a moment, if we just take a sort of step back, and I thought, what are the big themes that I have seen in contractual disputes, both on the construction side and the operational side? And I think three things stand out in terms of renewables. The first is, because of the very nature of the project, there is a certain difficulty in allocation of risks, which becomes very controversial. So in that case, warranties, exclusions, indemnities become, the sort of playground. The next aspect is the absence to price unforeseen events, which I think is a problem which happens even in traditional projects, but particularly with some of the technical issues involved in renewables, this is something that's quite important. And the third is more a sort of procedural point, and that is the absence of dispute management and resolution protocols, which you see in traditional construction projects in terms of how do you deal with sort of a dispute that comes along. Do you wait for, as Suba said, every payment notice is a dispute? How do you resolve it, or do you sort of wait till the end when they stack up and then you go and fight it out? And I think these are the three aspects. Now, if you look from the stage of construction, which I think where, at least in my experience, most of the disputes lie, the broad labels tend to be something we are very familiar with in construction, delay, defects, variation, design issues. But a very interesting aspect, which I've seen in renewable projects, is the sort of regulatory aspect and how it connects back to some of the construction disputes. So one of the theme that I've seen in some of the recent stuff I've done is about surrounding licensing, permission, consents. Who is responsible for them? What happens when they get delayed? What happens when it gets amended? It is not as expected when the project was tendered, or how the project was initially meant to do. What happens to the designs? What happens to the drawings? What happens to the as-built? And that's where the sort of application becomes very different. Now, on the commercial side, you have issues of sometimes a sort of clash of different standards, which I think was very classically seen in MT Hoivard versus Eon Climate, which went up to the Supreme Court, where it was the standards were general obligations and, you know, specific industry standards. Sometimes they don't sit very well. So how do you deal with a concept of the words need to be fit for purpose? How do you define that? If there is going to be a reference to some general standard, there's going to be a reference to an industry standard. How do you, when you talk about design life, how do you deal with that? You know, in Triple Point, we saw it was related to software, but again, energy software. How does that play out? We looked at the traditional concepts of liquidated damages, penalties. You know, how damages are calculated, when you look at liquidated damages, when you look at penalties. So I think the issues are practically the same, but the application plays out very differently. And I think the other aspect, when you also touched on, is a lot of these issues will then take you to more traditional JV disputes, between investors. How do you deal with them?
Okay, and Suba, are you looking at, is Siemens reviewing its FM provisions? I mean, you've had COVID, we've still got Russia, Ukraine, and it was an eye opener to me how much specialist steel in Europe came from Ukraine. So are you going back and fighting the last war, as it were, with your FM provisions?
It's not just FM, and it's not just Siemens either. It's through the entire supply chain, I should say. I mean, what has happened is previously there was a bit more certainty about risk allocation, you know, things like inflation. Who on earth could have anticipated Kwasi Kwarteng would destroy the UK economy last August, for example, and all my mortgage planning and everything went out the window. You know, you can't anticipate for that kind of thing. But in the new landscape, people are, or contractors, up and down the chain. And one fundamental point I'd like to appreciate is that we don't sit disjointed. There are lots of different parties, lots of different components, and as I say, particularly up and down the chain, as well as sideways, that everybody is taking a look again at the kind of risks that they would take before, whether they can continue to take them now. I think there is a recognition of that, and key issues are things like price escalation, things like what does force majeure cover, and so on. And a legacy issue of that is, although that might be what you're thinking about going forward, some people are trying it on to see if they can retrospectively review their contracts on the basis, well, we had never thought of this, and we think in the new landscape there should be a different consideration for it. So the short answer is, there's a lot more thought and risk averseness on some issues, but I suspect that may dissipate over time. The world might return to a bit more normality and stability, and then people will take risks. If I can just make a couple of points that was raised, Matthew. So, for example, governing law and dispute resolution, we rarely get disputes about the dispute resolution clause. I think most contracts, they're professionally drafted that they do tie those things down. So, you know, jurisdictional challenges, etc., are rare. But the challenge often is to avoid that is at the contract negotiation and drafting stage, because you need to have a regime that works for you where you are often piggy in the middle, and not have disparate or conflicting dispute resolution provisions to the extent that that's possible. So, you know, those are the thoughts. And the first three bullet point, conscious of time, all I would say is it is similar issues that come up, the time and cost money, etc. But there are differences, and sometimes there are just extra notes on there. So when you think about the liquidated damages payable for a barge, if you overrun, it's eye-watering. And then you have to think as a contractor, well, what risk can I take and how do I mitigate those kind of risks?
Yeah, I think one before we move on to the final slide, I think one plea I would make is for those of us who are trained as common law lawyers, when approaching these issues, to understand how different the approach can be from a civil law perspective, and perhaps the other way around, but certainly common law lawyers understanding, for example, basic principles around the doctrine of hardship, which may apply on a mandatory basis after all. And this, for my money, this contractual management of risk, particularly around FM and hardship, and maybe the doctrine of failed assumptions in Scandinavian law, this is an area where, as common law lawyers, there's a horrible risk that we assume things are broadly the same everywhere, and they're not. There can be a fundamentally different approach in the civil law, and I think that's something that I would lay down as really very important, particularly in the arbitration world, that we understand that. So I think moving on to the area which certainly I find particularly interesting. We've got two arbitrators on our panel here, and I wanted to ask Vivek and Wendy, certainly from my experience, one of the hardest things to do in renewables disputes is finding the right expert, particularly where you need an expert on a technical topic and it is new technology, and there may not be too many people who can say, well, I've worked with this for a decade. So that's been a challenge. But Wendy, you touched on a point earlier, which was the scale of compensation that is awarded and supported in particular by expert valuation processes and individuals in this area, and the kind of alarm bells that might sound around that, particularly in the context of transition and net zero, and particularly perhaps around the criticism in terms of ISDS. So use of experts in renewables disputes. Are experts, from your perspective, are they being used appropriately, responsibly? Are we being suitably diverse and imaginative in terms of where we source expertise from?
I'm not sure the concerns are unique to the renewables area on quantum, but certainly we are developing what are sometimes characterized as norms in commentary in published awards, certainly in articles, certainly in submissions, in relation to which valuation methodology is appropriate to use. And we tend to use a lot DCF income assessment approach and quantifying loss, and use a lot less cost-based approach and market comparables approaches. And I have never seen a eyebrow-raising damages award come out of a market comparables or a cost-based approach.
Right.
So I do feel that we're not giving enough thought, enough care, enough attention to what is the appropriate model to use, rather than, if we're acting for investors, what's the model that's going to get the most zeros on the bottom of our number, in the hope that the tribunal gives us somewhere in the middle. And that cuts both ways, right? I mean, a DCF can give zero in favor of a respondent as well, if you put the right assumptions into it. And then just backing up against that, Matthew, the assumptions that go into either selecting your market comparables for a market comparable approach, or for assessing your costs for a cost approach, or for the assumptions that you put into a discounted cash flow. That's where the other industry experts can actually be really, really valuable and really sensible, but it's still rare to see those inputs put in through the lens of economic transition, or the economic effects of a global transition from one energy type to another type. Yeah, those assumptions are not reflecting on the bottom line.
Thank you. Can I just ask, if anyone has any questions on this, please just pop them in the Q&A box, and we'll address them. Vivek, from your perspective, experts, is there anything particularly different or unique or challenging in the renewables area?
I agree with Wendy. I think there's nothing particular for the renewables area, but I think one complaint, if I should use that term consciously, I have both as counsel as an arbitrator, is sometimes there is so little engagement between the experts on the two sides that it is essentially you're left with choosing one or the other. And if the tribunal thinks that probably both are not right, you get to that classical situation of splitting the baby in the middle. And there is a lot of criticism that tribunals get for doing that. But I think that is something that needs to be addressed. I'll give an example. I was in a trial last week, actually, and both sides had deployed an expert. This is not a renewable dispute, it was a mining dispute. And they were from entirely different disciplines. Now, essentially, what was happening in terms of advocacy was I was trying to, shred his CV, one person's CV, the other person was trying to do that to our expert, but it was not helpful for the tribunal at the end of the day. Now, both the cases were pleaded in a way that the experts were sitting well with the pleaded case, but in terms of the core issues, both the experts were in different realms, so to say. And I think that
one question, sorry, Vivek, we've just had come up, which is bang on point in terms of what you're covering, is the answer for the tribunal to appoint the expert?
I think that would bring its own set of complications. I might be able to suggest something which is simpler. I think this was something that came up yesterday as well during discussion. A sort of a midstream CMC, a midstream where the cases have been pleaded. The tribunal is in a position to get the parties and their experts, and probably just the experts, to engage more and try and deal with at least not frame issues, so to say, but at least find some common ground so that at least the same set of things are being addressed, rather than you have a 200-page report on one side and a 250-page report on another side, and they're slightly going in different directions, and then you expected as an arbitrator, and I see this the second thing we have to discuss is tribunals as an arbitrator. What are you supposed to do? And we also have to bear in mind that a sizable pool of the arbitrators we end up using in energy disputes, or rather disputes generally, don't feel fundamentally comfortable with numbers. So
yeah, I want to pick up on that particularly. And I mean, Wendy, your perspective as an arbitrator, do you see a particular challenge in this area around arbitrators being sufficiently numerate?
Yeah, yes. And is appointing a tribunal expert a solution? Yes. Is it a solution that we run away from too much? Yes. I mean, how can you decide on something that you don't understand? And if you don't understand it because you haven't sort of spent the time in the discipline, either learning it as counsel or learning it in another career, in another life, then maybe you do need an expert to assist you. I would actually really, really benefit when I'm sitting from party appointed experts seeking to assist me more than seeking to become members of the advocacy team and making the case for the party that appointed them. And I appreciate the nuance in that. When I'm counsel, of course, I may approach that a little bit differently. But I have had a number of quantum experts say to me, oh, but it's very different in court because our role there, our duty there is to the court. And I think, well, hang on, there's something not quite right about that. So unless the quantum experts see their role as helping the tribunal get to the right answer, in a closer manner to what they do in court, I think, yeah, maybe we do need to let the tribunal get their own experts. And I certainly think if parties oppose that, then they can't really complain if the tribunal sort of comes up with a decision that they on the quantum that they don't think is what they think would make sense on the numbers provided.
Matthew, can I make just...
So I was going to say, Suba, you're the closest thing we have here to the user's voice.
Yeah, I'm conscious of time.
Arbitration is the party's process. So I think before I hand back to Ian,
sure,
I should ask you, from the voice of the user, what do you think about about tribunal-appointed experts? And
I mean, I was going to make two comments. You know, there's the run-of-the-mill, let's say, quantum and programming experts with their voodoo magic that we need someone to translate for us. And then you've got technical design experts, etc. In the latter case, and it sounds a little arrogant, but often we will say we are the experts in the field. We're the ones who are designing this cutting-edge technology. There isn't many people out there who can do better. But coming back to your question about tribunal-appointed experts, the practicality is, as a client, we would still have experts to deal with the tribunal-appointed expert, to assist us, to translate, to assess, to test that kind of thing. And therefore, from a cost-saving perspective and a risk management perspective, it doesn't really hold much sway for us to hand over that huge, and most of these cases are won or lost on the basis of your expert evidence. And to be able to not have the comfort that we've got somebody who can test what a tribunal expert is saying, and, as I use loosely, translate and interpret that for our commercial colleagues, it would be very uncomfortable for us to take that kind of risk when you've got tens of millions at stake. So hopefully that was a quick answer to your question, Matthew.
And do you play Vivek? Yeah,
I'd like to know. And I think I suspect you know, taking point from Wendy, I think the difference between courts and arbitrators, I think some arbitrators need to be like English judges in their words saying, you know, so and so was not entirely helpful, and you know, so that everyone reading that award knows that what the view of the expert was.
I remember being told at secondary school that X is the value of an unknown quantity and spurt is just a drip under pressure. But that may not be entirely appropriate. Well, look, on that note, I think, Ian, I'll hand back to you. But from my perspective, thank you, Wendy, Suba, and Vivek. Thank you for your insight. So, Ian, back to you, I think.
Thank you very much indeed for that. Thank you, Matthew. Thank you to Vivek, to Suba, and to Wendy for that fascinating discussion. It was a brilliant way to end our 3 days of conference this year for the annual ICC Arbitration Conference on promoting the rule of law. It has been a tremendous, tremendous event. So many people have told us over the 3 days just how much they've enjoyed it. And I'm sure the same is true of this session just now. You will all be sent following this week, during the course of next week, information about the conference. So do keep an eye on your emails, and we hope that's helpful. And so the final word is, that's it, folks. Thanks for joining us, and hope to see you next year. Bye-bye.